All right, if you're getting ready for the bar exams, you know that procedure is where cases are won and lost. Today, we're jumping into one of the most important strategic parts of the federal court rules, Part 26. This is all about ending cases early, and trust me, you absolutely have to know these rules inside and out. So let's get into it.
So picture this. You're looking at the other side's case and you're just thinking, there's no way. This is completely hopeless. It's flawed, maybe it's frivolous, or it just has zero reasonable prospect of succeeding. So what do? Do you have to go through the massive expense and time of a full trial? Well, no. And that's exactly what Part 26 is designed for.
Here's our game plan for today. We'll start by looking at the toolkit that Part 26 gives you. Then we'll dive into the two big strategies, the knockout punch, which is summary judgment, and the graceful exit, which is discontinuance. And we'll wrap up with the really important stuff, the consequences, and of course, the costs.
Okay, so let's open up this toolkit. Whenever you hear ending proceedings early in the federal court, your brain should immediately go to Part 26 of the Federal Court Rules 2011. Just think of it as your special set of procedural weapons, the ones you use to get a final result without ever seeing the inside of a courtroom for a full trial.
You know, Part 26 really does two completely opposite things. On one hand, it gives you the power to ask the court to kill off your opponent's case. But on the other hand, it also lays out the rules for how you can end your own case. Two very different strategic moves, all found in the same part of the rules.
And those two functions are split neatly into two divisions. Division 26.1, that's what I call the knockout punch. This is where you go for summary judgment to end your opponent's case. Then you've got Division 26.2, the strategic retreat. This is all about how you can voluntarily end your own case using things like discontinuance or withdrawal.
So let's talk about that knockout punch, Division 26.1, summary judgment. Now, this is an aggressive move, no doubt about it. You're basically marching into court and asking a judge to make a final call right then and there because the other side's case is just that fundamentally broken.
But, and this is a huge but, you've got to understand how courts feel about this. The bar for getting summary judgment is incredibly high. I mean, courts are really reluctant to stop someone from having their day in court. The power is used with, and I'm quoting here, exceptional caution. You have to show the case isn't just weak, it has to be completely hopeless, totally untenable, and guaranteed fail.
Okay, get your highlighters out. The rule you must burn into your memory for the bar exam is Rule 26.01. This is the one. Rule 26.01 is the source of power that lets a party apply to the court for judgment. This is your authority. Remember it, 26.01.
Now here's the critical part. You can't just show up and say, Your Honor, their case is weak. It doesn't work like that. To have any chance of success under Rule 26.01, you have to prove one of the 5 very specific grounds that are laid out right there in the rule. You have to be precise.
And here they are, the 5 commandments of summary judgment from Rule 26.01 Subrule 1. You have to know them cold. So, what are they? A. No reasonable prospect of successfully prosecuting the proceeding. B. The proceeding is frivolous or vexatious. C. No reasonable cause of action is disclosed. D. The proceeding is an abusive process. And finally, E. That the other side has no reasonable prospect of successfully defending the proceeding. You need to know these grounds, A, B, C, D, and E, like the back of your hand.
Knowing the grounds is only half the battle. You have to nail the process. And that's laid out for you in Rule 26.01, Subrules 2 and 3. It's a 3-step dance. 1, you file your application, and it must, I repeat, must have an affidavit with it. 2, that affidavit has to spell out which ground you're relying on, one of our friends from A to E, and the facts that back it up. And 3, you have to serve everything on the other party at least 14 days before the hearing. It's simple, but if you mess it up, your application is dead before it even starts.
Okay, let's switch gears. We're moving away from the knockout punch and into the strategic retreat. We're in Division 26.2 now. Look, sometimes you're the one who needs to end the proceeding. Maybe some bad evidence turned up, maybe your client's instructions changed, or maybe you reached a settlement. This is where the rules on withdrawal and discontinuance become your best friend.
Now, for the exam, it's so important to know the difference here. Rule 2611 lets you withdraw a specific part of your case. Think of it like surgical removal. You file a notice of withdrawal. But Rule 2612, discontinuance, that's the big one. That ends the entire proceeding, or at least a whole part of it. That requires a notice of discontinuance. So remember, 2611 for a small withdrawal, 2612 for a full discontinuance.
But here's the thing, you have to tell your client. Discontinuing a case is not a get-out-of-jail-free card. Oh no, there are some really serious consequences, especially when it comes to procedure and costs, and you have to know what they are.
First, a basic but absolutely critical procedural step under Rule 26.13. You have to serve the notice on every single other party in the proceeding. It's not enough to just file it at the court. You have to tell everyone, and you have to do it as soon as reasonably practicable. Don't forget this.
Now, this is a massive strategic point, and it comes from Rule 26.14. Just because you discontinue your case, it does not mean the other side can't sue you again for the exact same thing. Discontinuance is not a defense to a future claim. So yeah, it ends this particular fight, but it doesn't stop another one from starting tomorrow.
And now for the big one, costs. Meet Rule 26.15. I like to call this one the costs hammer. If you discontinue, you're almost certainly going to get a cost order against you. And if you don't pay those costs and then you try to start a new case about the same issue, well, the other side can use this rule to ask the court to stay or freeze your new case until you've paid every last cent. It's a really powerful rule.
Okay, let's lock all this in for the exam. Summary judgment, that's Rule 26.01. Remember the super high bar and those 5 grounds, A to E. Discontinuance, that's Rule 26.12, and it's your choice to end your own case, but it's a choice with consequences. You must serve the notice under 26.13. It's not a defense to a future claim under 26.14, and if you don't pay the costs, your future case can be frozen under the mighty Rule 26.15.
And that really brings us to the final question, the one that separates someone who just knows the rules from a real barrister. It's not just about memorizing rule numbers. The true skill, the art of advocacy, is looking at a case, weighing up all its strengths and all its weaknesses, and knowing the right moment to advise your client to go for that knockout or when to make the smart, tactical retreat. And that, right there, is the judgment call you'll be making for the rest of your career.